I filed a notice of appeal and the Court of Appeals said,
You done fucked it up again, didn't you? You done fucked it up again.
Alex here with part 217 of the My Docket series on child custody and visitation. As my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. That cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into the order reversing and remanding from the Court of Appeals again. For the second time, my mindset was, elated, but also annoyed. I felt like this was such a silly appeal that just why did I have to do all that just to get what I was supposed to get in the first place? And I'm not sure what to say beyond that. One of my viewers did mention that maybe the judge was frustrated about the fact that my ex was already going to lose the 1,750, or yeah, it was around that. It was like 1,750 or 80, something like that. Maybe she was frustrated about her losing that money, and so she didn't feel she should have to pay another $250 in costs. But my answer to that is she never lost the money. She was just not allowed to get the money that she was ordered, to get. That was money that was wrongfully ordered to be paid to her. And so my opinion is she never lost anything because nothing was taken from her. She just wasn't allowed to collect an attorney fee award that was illegal under the law. So in any event, what really matters is the conclusion, not so much what the judge wants or doesn't want to happen. Because if you think about it, the judge just made her situation worse, because now not only does she have to pay the $250 in costs that she would have had to have paid anyway, but now she has to pay an additional $250 in costs for the second appeal. So if that was really the intention of the judge, then, her good intentions ended up doing no good for my ex. It just made the situation much worse for her. So she's going to end up losing the $1,700 attorney fee award, and now she's going to end up getting hit with a $500 in costs instead of $250 in costs. So for people who thought maybe that was what the judge was thinking, I would say just take a look at the video Meta Rulings. That is an inappropriate way for a judge to behave. Meta rulings are some of the types of rulings that end up looking totally weird and nonsensical to people who aren't privy to what the judge is thinking, because when you look at meta rulings objectively, they don't ever make any sense. There's just always something wrong that just doesn't fit. And both with the last appeal and this appeal, people will see that in the judge's orders. They're just, the order doesn't make any sense. If you have legal training, it's more obvious than if you don't. But one thing that you can tell without legal training is that an order reversing is bad. And it's the recognition of a mistake from the high court, whichever court happens to be reviewing the decision, in this case the Court of Appeals. So I think at this point, all that being said, let's go ahead and take a look at what the Court of Appeals has filed.
See, it was done fucked up, and you decided not to unfuck it.
Here we have the order of reversal. The standard introductory paragraph indicates that I am appealing a district court order denying costs from a prior appeal. It identifies District Court Judge Bridget Robb as the judge who has entered the erroneous decision. I previously appealed an award of attorney fees to my ex. This court issued an order reversing the award and remanding the matter to the district court for further proceedings. Upon remand, the court denied my costs incurred on appeal. This court reviews a district court's decision whether to award costs for an abuse of discretion. A trial court abuses its discretion when it acts in, quote, clear disregard of the guiding legal principles, unquote. I'm arguing that the district court did not have the discretion to deny me costs under the law because I obtained the relief I sought from my prior appeal. The law provides that the court may only utilize discretion in considering costs on appeal where a new trial is ordered or a judgment is modified. Otherwise, quote, in the event no order is made by the court relative to costs, where a new trial is ordered or a judgment is modified, the part obtaining any relief shall have his or her costs, unquote. Under the circumstances of the present case, the statute mandates costs to Falcone. I love how they go in here and they help her understand the definition of the word shall by noting that the word, quote unquote, shall is generally regarded as mandatory. And that they also cite the same case I cited, Keever v. Jewelry Mountain Mines, which has held that mandatory requirement of the law in awarding costs is clear, emphatic, and peremptory. The district court's denial of costs on appeal is contradictory to the law, and they therefore will reverse her decision. When they say clear, emphatic, and peremptory, they mean clear, emphatic, and peremptory. And to me, this is no surprise that this decision was reversed. The law could not have been read any other way. The other thing that I'd like to mention is you may notice that my ex did not file a response. That's because in this appeal, she did not file an opposition to my motion. Because the judge denied my motion without my ex providing any input, my ex was not allowed to provide any input on appeal because no arguments would have been preserved since she never made any arguments. This is what left the judge so vulnerable to being overturned on appeal. It was the fact that they were only going to hear one side. In any event, it didn't matter because the law was so abundantly clear and this particular issue was so simple for them to resolve. Going into the next document, the remittitur. This is indicating to the lower court that the Supreme Court, specifically the Court of Appeals as well, is done with this appeal. They are sending the case back to the lower court, and they are turning control over these particular issues back to the lower court. If you want to learn more about the remittitur, please watch my video on the topic, filing an appeal. Going into the aftermath, I didn't file any documents, so I incurred $0 in costs. My ex didn't file anything either. She incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex didn't participate in the appeal, so she didn't have an attorney either, and she incurred $0 in attorney fees as well. As in my previous videos, feel free to post any questions you have down in the comments below, and I will see you guys next time.